Hello, everyone. Thank you for joining in. We will be starting our webinar in under a minute. All right, so it's 12 o'clock. We shall get started. Prashanthi, just to make sure my screen is in share mode. Is that right?
Yeah.
Fantastic. All right. Thank you, everyone, and welcome to this webinar. My name is Vishal Sharma. I'm a consultant and I'm the moderator for this session. Today, I'm joined, I have Prashanthi Reddy with me. Prashanthi is a distinguished lawyer. She has been practicing in this segment for quite a few years by now. She is a graduate from University of Pennsylvania Law School from 1996. And she's been in the immigration field since 1997. So there's a lot of experience backing her. And she's admitted to the bar in New York. She's a member of the American Immigration Lawyers Association and the New York Bar Association as well. Along with this, she is also the immigration chair for the National South Asian Bar Association and co-chair for the Federation of Indian Association. So there's a lot of activity going on there for Prashanthi when it comes to immigration. And she's also actively involved in pro bono legal work. Today, we will be covering H1B layoffs and revocations. So on that note, I would like to pass the control to Prashanthi.
Hi, Vishal. Thank you for those kind words. So I thought that today we would structure the presentation on our webinar on layoffs, simply because that seems to be the need of the hour. We're seeing a lot of layoffs of H1B workers. We've been reading about that in the news. All the big companies seem to be laying off their H1B workers, and obviously it's a struggle. I mean, for anyone, a layoff is a struggle, but especially if you're on a non-immigrant visa, then it's more of a struggle. So because it's not just financial, then it's also your immigration status and your ability to remain in the country. And your family members' ability to remain in the country also gets affected. So that's why it becomes so important to guide people about what their options are when in case of a layoff. And this is something that you never know when it'll happen to you. So it's always good to have that information handy in advance, so that you know what you can do, and you don't need to panic in the last moment. So previously, ever since 1990 until almost 2017, there was no grace period for H1B workers if they were laid off, or if they left the job for some reason. There was no grace period at all. So the day that they left, the next day they're pretty much out of status, and they would have to leave. And everyone always was under the impression, clients would always call me and say, oh, so I've been laid off today. How long can I stay in the US? And I would always respond 0 days. You have to leave the country immediately. And they'd be like, but that's impractical. That doesn't make any sense. How can I leave immediately? I have a house, I have a car, my child is going to school, etc., etc. So I can't just, get up and leave. And that makes sense. And I guess USCIS has finally come to its senses and come up with a practical and reasonable kind of law to bridge that gap when you get laid off. So as of January 17, 2017, there, and this is almost the best law that's come out with reference to H1B workers. So there's a 60-day grace period after your employment is terminated. So again, it could be a termination from the employer's side, or it could be that you voluntarily, have decided to resign the company. It doesn't have to be a termination from your employer's side. So that's something to keep in mind. So this allows workers 60 days grace after the last date of employment to find a new employer, or to, so you could either file a transfer during those 60 days grace, or you could also file for a change of status, or you could use that 60 days to, leave the country, to, prepare yourself to leave. As we all know it, you can't just get up and, walk out after being in the US for, a couple of years, or even if it's a year or whatever it might be. There's always some preparation required. So this is really a good law, and this helps a lot of people. Of course, 60 days is a limited period of time, and there are issues that come up even with the 60-day grace period. So I think it'll be a good idea to then go into what those issues are. If we can have the next slide.
Sure. And Prashanthi, before we move on to the next slide, this one is for everyone who's joined us. You will have an opportunity to ask your questions and get them answered. We do have a Q&A round scheduled for the end of the presentation. So what you can do is you can either drop in your question in chat at any time during the presentation, or you can keep your questions handy and then ask us over chat when we are starting the Q&A session.
Okay, so going on to the next slide then. So one of the issues that comes up with layoffs is the fact that employers have a duty to notify USCIS upon termination of employment. So, most employers, unfortunately, that duty comes from the law, 8 CFR 214.2 H11. And, while companies don't really want to do this because they don't want to needlessly prejudice their employees' interests or their ex-employees' interests, the fact is that they have to do it by law. And if they don't inform USCIS as soon as the person leaves, so what the employer needs to do is apply for withdrawal of the H1 by mail to the USCIS, informing USCIS that so-and-so person is no longer working for them. And then what happens is USCIS will then withdraw that H1B, and upon withdrawal of the H1B, the person is really falls out of status. The person is also out of status as soon as they leave the country, and we'll talk about that later as to what these two different out of statuses mean and how they affect the employee. So yeah, the fact that employer has to notify USCIS as soon as the employee leaves adds an additional complexity to the employee status, because otherwise if the employer didn't notify USCIS and if the H1B was not actually withdrawn, then you could argue that the person can still, remain in the country to a certain extent, and because USCIS does not know that the person has stopped working. And it's possible after that even without the 60-day grace, or even beyond the 60 days grace, the person can still apply for an extension or change of status, but not with, the present pay stubs. They'll have old pay stubs, and sometimes USCIS does approve those cases under the non-protunct law, under humanitarian grounds. So, but with the termination of the H1B and the withdrawal of the H1B, that is really out of the window. So you can't really file for a change of status or an extension. Of course, you can based on the 60 days grace, but beyond the 60 days grace, you cannot. And in the past, you couldn't whatsoever. So this employer's duty to notify USCIS is a big deal and causes a lot of trouble for employees. The other issue that we should talk about, that we were just talking about, is maintaining of status versus the the bar, the 3 and 10 year bar. So that's another thing that triggers as soon as you are terminated from your employment. So just to explain, the 3 or 10 year bar is it's triggered when a person remains in the United States for more than 6 months or longer beyond their authorized period of stay. Then they're subject to a 3-year or a 10-year bar. So if you're 6 months or more, then it's a 3-year bar. But if you're over a year, then it's a 10-year bar. So what does it mean by remaining in the US beyond the authorized period of stay? So that's when your I-94 either expires. So you file for an extension, you got 3 years. At the end of the 3 years, unless you've again filed for an extension, you have to leave the country. And if you remain beyond the expiry of your I-94, then you're accruing unlawful presence. Okay, so that's what unlawful presence is. And in the scenario of the layoffs, if you remain in the country beyond the termination of your H1B, as we just said, USCIS requires employers to notify them when you leave employment, and they then subsequently withdraw the H1. USCIS withdraws the H1. So when that happens, that's also something that triggers your 3 and 10 year bar, unlawful presence. That is, of course, subject now to the 60-day grace period. So if you're doing whatever you need to do within the 60 days, then all this goes out of the window. But if it goes beyond 60 days, then yes, all this 3 and 10 year bar will apply to you. Now, the other thing that happens is you may not be accruing unlawful presence, but you might simply be out of status. And that happens when, for some reason, the employer maybe does not withdraw your H1, but the employer stops paying you, lays you off, maybe for a temporary period of time. During that time, you are out of status. You're not in status. You don't statutorily, you're not subject to unlawful presence. So when you leave the country, or if you're trying to file an extension or change of status after that period, you could still, there could still be serious penalties and implications, because when you leave, and if they find out that you were not working during a certain period of time, they can refuse. Again, it's based on their discretion. Unlawful presence, if you leave the country, consulates simply cannot give you a visa because you're barred by law. But if you're out of status and you're not accruing unlawful presence, then the consulates can refuse entry as per their discretion, because they think that you may not, you may again come back to the US and then again not maintain status. So for that reason, they may just refuse entry into the US. And also when you're filing a change of status, when you're out of status, they would again only approve your change of status or extension or transfer based on humanitarian grounds, based on a non-protonc application. So that's something to remember. Both are bad. Being out of status, unlawful presence, both are bad, but unlawful presence is worse because it's statutorily a bar. But remember, this bar applies only when you leave the country and try to come back for unlawful presence. So if you don't leave, you're fine. You don't accrue any unlawful presence. But if you leave and then try to come back into the country, it's a funny thing. Then that's when the unlawful presence law comes into the picture. Going to the next slide. So another issue, just talking about some of the problems that we face, again, in addition to unlawful presence and being out of status, when you're laid off, the problem is you will not, in most states, you will not qualify for unemployment benefits, even though you've been paying, and your employer is paying insurance, etc. You may not qualify. The reason being is that unemployment benefits most states require that the worker be available and ready to work in order to receive unemployment benefits. But unfortunately, if you're on a H1 status, you're not really immediately available to work. because the person that hires you has to file a H1. The job that you are working that you get should qualify for a H1. So really, there's no possibility of immediately working, and therefore most states may refuse to give you unemployment benefits. So that's something to definitely keep in mind. And going to the next slide then. Okay, the next one is basically information about how portability can help you. There is, I mean, we've seen all the issues that take place because of being laid off, but there's some help. We saw that there's the 60 days grace period. There's also something called AC-21 or H1B portability that can help ease the pain when you're laid off. So H1B portability basically comes into play when you find your new employer. So you've, say, been out of a job for 30 days, and within 30 days or within 59 days, you find another employer. USCIS allows you to work immediately. So some of the pain of loss of income is removed here, is mitigated, because there's a portability law which allows you to work as soon as your petition is received by USCIS. And the portability law applies to the 60 days grace period as well. And it applies in other circumstances when you're filing a transfer, when you file extension. That's when portability law applies as well. So you don't have to stop working. Or in this case, you can start working earlier. You don't have to wait for the approval in order to start working, because we know the approval can take 3 to 4 months unless you file premium processing. And even then it could take 3 to 4 months if there is a request for further evidence. So portability is allowed, meaning that you can work as soon as the USCIS receives your petition under certain circumstances. So the worker has to be obviously lawfully admitted to the US, so you should have come lawfully. You should have previously held a H1B, so this is a situation of a transfer or an extension. And the new employer filed a non-frivolous H1B petition. So while they still could, and in this case, they filed on the 59th day. So it is within the authorized period of stay because of that 60 days grace period. And also the non-frivolous H1B petition should have been filed, which means that they can't just file a H1 without having any work for you. They should actually mean to hire you and not just file a H1B petition for the sake of safeguarding your status because the employer is your friend. So it has to be a non-frivolous H1B petition, and also the worker did not work without authorization since his last lawful admission to the US. So he shouldn't have ever been out of status or unlawfully present. So based on all this, the H1B portability is definitely possible. We can now go to the next slide. So what is the other benefit that you get being laid off? Is there anything else? So the other benefit is the employer's obligation to give you return transportation. Not really a benefit, but something is better than nothing. So employer is obligated to transport you to your home country, place of last foreign residence, meaning buy you a ticket and help you with moving costs, etc. So this is not applicable for your family members, but definitely for you. And having said that, USCIS has not really enforced this law of return transportation to home country law. So it remains to be seen if the employer doesn't do it. will USCIS have to come after them or, make them pay any penalties, etc. But generally employers do it because they know that they're under the obligation to do it. So that's, one benefit you could say. Next slide. Now coming to the alternatives. What do you do if you're laid off? What are the possible alternatives that you have? One of them is certainly if you have EAD. So say you're on a H1, but you also recently filed your 485 based on approved I-140. And if you got an EAD approved because of that, you might still be maintaining your H1B because you don't want to give it up. There's certain benefits of having a H1. But say you were terminated, what then? Do you have to leave the country in such a situation? What happens to your green card? Can you use your EAD? These are the questions that often come up. So you can certainly use EAD and you can find another employer using EAD. However, if you use EAD and if your 485 gets denied or if your I-140 is not yet approved, if it's still pending, and then if your I-140 gets denied, then your 485 gets denied as well. Then you fall out of status because you don't have a H1B. You don't have an underlying status except for the pending 485. So that's a risk that you're taking. Also, presumably the person who laid you off or terminated you might be the person who filed your I-140. So they might be your employer who's sponsoring your green card. So then what happens to your green card? We have to remember there's something again called AC-21 where you can move employers as long as the employment is job is same or similar. You can change then to a different employer under AC-21 by filing a 485J. So that's what happens if you're on a GC and then you get laid off. And the other thing to keep in mind is if you use your EAD, then you cannot move back to a H1. You cannot file a change of status again to move back to a H1, but you can leave the country and come back on a H1. So that's another scenario to keep in mind if you have a pending GC and you get laid off. Next slide, Vishal. Some additional statuses that you can change to after being laid off. You could certainly change to a student status, to an F1. You can file a change of status, which is an I-539 application, because it might be that you don't get a job within the 60 days grace. And then, these alternatives come into play then. Filing a change of status is easy enough to an F1, but there might be some complications simply because of the logistics of everything and the timing. So when you file a change of status, it's taking a long time. And because of this, when you actually get approved, it could be that, your classes have already started or your classes have not yet started. So you have to make sure that your approval coincides with the time when your school starts, because it can take 10 to 12 months to get an F1 when you're filing a change of status. The processing time is really long. So just, talk to your DSO and make sure that they're able to, that you're able to join school as soon as your F1 gets approved. Same thing with a change of status to a B2. It takes a long time. Processing time again is 10 to 12 months. And so the problem here is you can ask for 6 months, right, at a time. So by the time you ask for that 6 months period of stay, and by the time you get the approval, usually the time period that you've asked for will be over because it comes in 12 months and you've asked for 6 months. So you should always have, you should know that your status is only for 6 months. And before the 6 months is over, you should then plan to file either an extension or again a change of status based on a pending petition. So say within the 6 months period while the B2 is still pending, you get a job, then you'll have to file for a change of status from a B2 to H1 while that B2 is still pending. So that's a bridge petition It's a little messy because you have a pending petition. You don't actually have an approved petition. So something to keep in mind, a bridge petition, USCIS will approve it as long as the underlying petition is approvable, even though not approved. Now, another status that you could change to, the most easiest of the change of statuses is the dependent status. So if your spouse happens to be on L1 or H1, you could then presumably change to a H4. And in some instances for H4, you could work. You could file for change of status to H4 and an EAD as well. And once you get that EAD approved, you could work. So that's, in place of a H1. There would be some time where you may not be able to work because again, a H4 EAD does take 6 months plus to get approved. But if, so once it does get approved, you can work. For an L2, that's the dependent of an L1, much easier because once the L2 gets approved, you're automatically eligible to work. You don't have to file an EAD. So that's the advantage of, if your spouse is on H or an L, changing to a dependent status is definitely better than changing to an F or changing to a B2. On an F also, you could presumably work once you go to school and you apply for a CPT. On curricular practical training while you're studying, it's possible to work, but it's a whole process and it's much more lengthier than going on a H4 or an L2. Next slide. So I think we've covered all the topics. We could now, I have, just come up with a few frequently asked questions just so that, because I am leaving time for the audience to ask questions, but sometimes you may not think of these questions. So I thought, it might be a good idea to bring them to light and, answer them. And if there's still questions that you have, I'll be more than happy to answer. So the first one is, what steps can I take before my H1B gets revoked? So there are instances in which, yes, you have the 60 days grace period. But remember, guys, and I have not said this before, but I must say it now, the 60 days grace period is discretionary. So the USCIS may decide not to give it to you. It's not that you have the right for a 60 days grace period. That's one thing. Second thing is the 60 days grace period occurs only once per your H1B. So you can only use 60 days grace period for the one time for the duration of your each H1B. So if your H1B is for 3 years, you can only use a 60 days grace period once. So you can't use it 2 or 3 times during your H1. So if you're in a situation where you've used up your 60 days grace, or you don't want to use it because the 60 days grace is is discretionary and you don't want to take any chances, there is another way out. We have to remember that while your H1B employer might have sent out the withdrawal, it does take time for, between the withdrawal and the request to withdraw and USCIS actually withdrawing your case. And you could take advantage of that time. That could be a 30-day time period between the time that USCIS actually acts on any of these cases. So if it could be 30 days, it could be 60 days if you're lucky. So what you could do is if you have employment, you can file immediately for a change of status, or you could file immediately for a transfer of H1 while your withdrawal petition is pending, because your H1 is not yet withdrawn. Or you could even do it while, sometimes employers are kind enough to give you a 2 weeks notice. You could even do it during that notice period. And, safeguard your status and not have to use the 60 days grace. So there's, other steps that you can take in addition to the 60 days grace to, change status or transfer your status. Next slide. Now there's another thing called the 10-day grace period. It's different from the 60 days grace, and I just wanted to highlight that because I wanted to differentiate the two, because there's some confusion usually on what the 10 days grace period is. The 10 days grace period applies when your I-94 actually has expired. So USCIS will give an automatic 10 days for you to leave the country or to file for an extension or a change of status upon your original expiry date of the I-94. Something to keep in mind, so that you'll have at least those 10 days. And this has always been the case. This has always been the law. So this is something that, to keep in mind. But this only happens when your I-94 expires, not upon terminations or getting laid off. Another tricky thing is trying to reinstate a revoked H1. So sometimes employers might change their mind. They might lay you off, send out the withdrawal, and then decide that things are not as bad as they thought they were, and they want to hire you back. Is it possible then to revoke the withdrawal? It is possible. They have to write immediately to USCIS telling them that they don't wish to withdraw the H1. But oftentimes, the mail gets crossed, and USCIS would most probably not notice that there is a request to take back the withdrawal, and this doesn't always work. It's messy. So though it's worth a try, it may not work. But if you have the 60 days grace, the employer can then just go ahead and file another extension for you, another transfer or an extension, even though your H1B was withdrawn, because you have the 60 days grace. So instead of another employer doing it, USCIS could then do it. Next slide. So how can I check if my H1B is revoked? Unfortunately, you will not get notification of it. Only the employer is notified of a revocation. The withdrawal notice or revocation notice actually comes in the mail. But you can check online. If you have your receipt notice, you can check online. The tricky thing about checking online is USCIS does not always update its website database to inform you of the revocation, but that's the only way for you to check. Of course, you could ask your employer or your ex-employer, and they could send you the notification, the withdrawal letter as well. I think with that, we've covered everything.
And yeah, everyone, this is now a timely reminder that if you have any questions, now is the time for you to put in your question. If in case we are not able to get to all the questions today, we will leave our email address with you so that you can drop in your question and we can pick it up from there. So I'll get started with a few questions that I can see. Okay. Hi, if an employee almost exhausts his 60 days grace period, is it possible for him to go to change of status to an F1 student and later come back to H1B once he gets another job?
Yes, that's absolutely possible as long as you're not subject to the cap. You can file for a H1 at any time. But of course, the problem with this is that I was just telling you about the F1, right? The processing time is so long. So if you get a job in between, then you'd have to file for a petition based on a pending petition, which is a bridge petition. But if you do get the job after you're actually on F1 status, then yeah, you just have to file a change of status from an F1 to a H1. Make sure you're maintaining your F1 status so that they approve the H1.
Okay, all right. Before I go on to my next one, I see a few hands raised. What we would suggest you is please drop in your question in chat and we'll be picking up from there. So the next question is it possible to transfer H1B without pay stub where you don't know if your employer has terminated the H1B or not?
Right. So in that situation, I would, since you don't know, I would file a change of status anyway or a transfer anyway as soon as I possibly can. You are taking a chance. And with reference to the lack of pay stub, as I said, you could always use, you could say on humanitarian grounds, use the nunc pro tunc exception and file for your transfer of H1, but you should do it sooner rather than later, so that even if the employer has revoked, maybe the revocation has not yet come into play, it is not yet approved.
All right, I hope that answers. Next one is if we move from H1 to H4 due to some legalities, again, we are changing to H1 as we get a job. Will it have any past impact while being approved?
No, I mean, there's no impact on filing change of status requests. As long as you've always maintained your status, changing from a H4 to a H1 basically means that you should be maintaining H4 status, and that is possible if your spouse is maintaining the H1 status and if you continue to be married to your spouse. So as long as you're maintaining your status, there is no issue with filing a change of status from a H4 to a H1, as long as you're not, again, subject to the cap. If you're subject to the cap, then of course you'd have to wait for cap season in order to file.
Got it. Okay. What can we do if employer is not giving you approval notice or I-94?
Not much, because the way the law is structured around H1B is employers have a lot of power over their employees. And the 60 days grace is one of those exceptions where, they've given some power back to the employees. But if they don't give you, they're supposed to give you the I-94. They're supposed to give you a copy of the H1B approval at least. And when you're going to the consulate, you have to have the original H1B approval with the I-94. So you could complain to USCIS, you could complain to the Department of Labor. That's about as much as you could do. Or you can inform your employer about what the law is and hope that the employer follows the law.
Yeah, that was an interesting one. Moving on to the next one, I have 2.5 months PO remaining in my previous project. PO was between my employer and an implementation partner. Can we use that H1B extension after I-140 and then under brackets waiting in India?
I don't know. I mean, so if you're out of the country, if you're in India, your really doesn't matter, what your status is, because you're not covered by immigration rules. But if you have to file a H1, then the employer has to have work for you, right? Even though they're not looking at it that closely to see, they don't expect the employer to have, if you're filing for H1 for 3 years, say, they don't expect employer to show a PO for 3 years, but you have to show a reasonable amount of time on the PO, and most probably at the consulate, they will ask for a vendor letter or client letter, something like that. And if the vendor says that you only have 1 month left or 2 months left, I mean, that could have an impact on whether the consulate gives you a visa or not. So something to keep in mind.
Okay. The next one says, when you spoke about H1B portability rule and that one can work after USCIS receives petition, did you mean an employer does not have to wait for the receipt notice / receipt number?
Correct. The law has never been that you have to wait for the receipt notice. I mean, it's prudent to wait for it sometimes because, USCIS could, you might think you've sent it and everything is fine, but USCIS could return it because you didn't send a check, or, the fee was wrong, and then you start working and then it could be a mess. So it's prudent, of course, to wait for it, but you don't have to as per the law. As per AC 21, the USCIS should have received the petition. So as long as you have a FedEx or UPS or confirmation that they have received it, that is sufficient for you to start working.
All right. Okay, next one, you have to bear with me. There is a string of questions on that one. Okay, I'll have to break it down. So the first one here is, if my employer withdraws my H1B, do I still have the 60-day grace period?
Yes, that's what the 60 grace period is about.
Next up, what is the chance of status option you mentioned? If I apply for H4 and USCIS receives it, could I start working? I guess, yeah, sorry, continue.
So you can't automatically work on a H4. Your spouse should have an I-140 approved in order for you to qualify for a H4 EAD. And if they do have an I-140 approved, then you have to file for I-539 application, which is a H4 application, and an I-765 application, which is an EAD application. You can file for both concurrently. And once your EAD application is approved, that's when you can start working.
Okay, yes, it was a lengthy one, and then the continuation was that my spouse has an I-140 approval. What are my options considering that? Could I change status being in US, or do I need to go out of the country? I guess you've covered most of it, but
yeah, you can change status. You don't have to leave the country. You can file a change of status.
There you go.
Provided you file it within the 60 days grace.
Okay, all right. The next one, I guess it's a bit of a hypothetical one. Suppose I do have H1B transfer, or I do H1B transfer from company A to B and also to company C. After resigning from company A, can I join company C if company B rescinds the offer?
So this is like a math problem.
Yeah.
But yeah, so you have to always remember that whatever application you filed last becomes your application that they will look at and which determines your status. So it's called the last action rule. So if you filed your H1 with C last, then that becomes your status automatically. Unless you withdraw an application before it gets approved, whatever application you file last will determine your status.
Okay. The next one is more of a consultation here. Is it better to go home country for some time and get a job, will return to US on H1B?
Yeah, I mean, you don't have a choice. If you don't, I think rather than filing, I mean, it depends on your circumstances, of course, but rather than filing a change of status to an F1 and then filing to or a B2, sometimes it might just make sense for you to leave, take a break, and then find a new job and then come. But some people can't do that simply because they have family here, or their children are studying here. So it sometimes becomes difficult to leave, but if you can, then that's definitely a cleaner way of doing it.
Okay. I'm not sure the next one is an independent question or a continuation of a follow-up, but is it the right time to come to US by this time with new H1B?
Well, it's always a good time or a bad time. H1Bs are easier to get approved now when compared to under the previous government administration. So in that sense, it's a good way, but there are other things as well, right? There's a recession or
multiple factors there.
Multiple factors, so you have to make that decision yourself. There's also the consulate. I don't see that the consulate is being extra strict or anything like that right now. It's just that the consulate is, especially if you're from India, the visa appointments are not that easily available. So all those factors you have to keep in mind.
Okay. The next one is, to my understanding, is converting to H4 better than F1?
Yeah, definitely, because a H4 will give you, it's possible that it will give you a EAD. That's one thing. And second is H4 is a more stable status to be in. If you have to go to an F1, first thing is the processing time is long. And as I was saying, once you get the approval, you should still be able to attend classes. You have to pay for, an entire semester, so it's expensive. So if you're able to do a H4, it's definitely a good idea. Again, depends on your circumstances. If you want to do a H4 and you want to work and you cannot apply for an EAD because you don't qualify, then maybe F1 might be a better option for you if you're able to qualify for CPT at some point. It really depends on your situation.
Okay. The next one is, can you start classes before change of status to F1 is approved?
That's a good question. And some schools do allow you to start classes while you have a pending petition. So you should really contact your DSO to find out whether they allow that. If they do, then you don't have to worry about the logistics of, when your approval comes and whether you've missed classes or, how it works then. So unless a school has rolling admissions, it might be an issue.
Okay. Before I go to my next one, we have 15 minutes left. So for the interest of time, we will be taking a few more questions. And as I mentioned, if you're not able to get to all of your questions today, or if you have any additional questions, we will be dropping you our email so that we can connect over mails. Next one is, shall I change my employer without any intimation?
You could, of course, if you want to. No one's stopping you from doing that. You don't have to intimate. I mean, as per immigration law, you don't have to intimate your employer that you're leaving.
Okay. Next question is, after I-140 approval in first week of October 2022, neither beneficiary nor the employer has taken any actionable decision. What is the meaning of, under quotes, case was sent to the Department of State at USCIS case tracker?
I'm sorry, what was the meaning of what?
What is the meaning of, under quotes, case was sent to the Department of State? I guess that they're just trying to get the specifics of, that's the update.
So I'm not sure whether it was your H1 approved or not
yes.
approved. It was approved.
After okay, there's no mention of H1 here.
Yeah, but so I'm not quite sure whether your H1 has been approved or not. After the H1 was approved, did they say they're sending it to Department of State, or did they said they're sending it to the Department of State before the approval, maybe to look into some things? Maybe they want to check on something in your home country. Maybe there's some concern. I am not sure. So that would be a very specific question. Again, I don't have all the facts as well. So unless they want to ask the question again and give me all the facts, then I can try to answer that better. Or
what you can do here is, Rajendra, you can drop us an email and we'd be happy to take you up.
So I think I'm just reading it, Vishal. After I-140 approved in first week, it's I-140, not H1.
I-140, yeah.
Neither beneficiary nor employer have taken any, I don't know what action should be taken after it's approved. What is the meaning? Case was sent to Department the USCIS case tracker. After I-140 is approved, they're saying it was sent to the Department of State. I have no idea. So maybe we need to look into that further. Maybe there's some facts that are missing.
Yes.
Or maybe it's just a mistake. USCIS does sometime when they're updating status, they make mistakes in updating the status.
Mm-hmm.
It's all speculation, so I'd rather not speculate.
Yeah, that's the right thing in this case. The next one, I guess, is a bit of a hypothetical one. I'm working with A and plan for my travel and stamping process through A, still working with A, but in between, I got an approval from B. Will it impact for my stamping? In a simple term, can I have more than H1B approvals while going for a stamping? I guess more than one.
Yeah, so, but again, it depends on how he filed. Did he file the H1 second H1 as consular processing? Did he file it as a transfer? Again, it's the last action rule, right? So if you're in the country, you have a H1A, a H1 through A, and then you get a H1 through B while you're in the country, then you really have a H1 through B. But if you're not in the country, then you could argue that, you know, you can use either H1s because you're not really in the country. Immigration rules with reference to transfer don't apply to you. It's not really a transfer anymore.
Mm-hmm. Yeah, some of these are very specific questions, and
yeah, so we need a few more facts to
yes.
answer that question accurately. But I'm just telling you both hypotheticals, how they would work.
Absolutely. And this is, again, a good opportunity for me to remind you that if you want to take this offline, please drop us an email and we'd be happy to schedule a follow-up consultation. Next one is, one of my consultant is going to complete her grace period by this month, 17th, December 2022. What is the alternate option for her? She don't have project confirmation. Even she didn't apply for change of status too. Please advise.
So you have time, you have 10 days time, 7th to the 17th. If she doesn't want to leave the country, then she can apply for a change of status. Now, since, you know, it looks like you've laid her off because there's no job. If you're not able to find a job for her in the next 10 days, then it's best that she either files a change of status or she leaves and then comes back, you know, once you have a job for her.
Mm-hmm.
But remember, you have an obligation to withdraw for H1.
Great advice there. Next one is, I am on J2 and have EAD. I am planning to transfer on H4. While this change of status is pending, can I still work on J2 EAD, or after the J1 waiver, I cannot work on J2 EAD?
In general, when you file for a change of status from one status to another status, you remain in status quo, so in your present status until your second status gets approved. So in this case, if she filed for change of status from J2 to H4, she remains presumably on a J2 and she gets all the benefits of a J2 until the fact that her H4 is approved. Now, I am not certain about J1 waivers because I don't do J1 waivers. So I can't answer that question with reference to when you apply for a waiver. If you're still on a J2, then if you're still on a J2 EAD, then you should be able to work on it as long as you're maintaining that status.
Okay. Lots of more questions there. I hope we are able to get through all of it. Next one is, will I have to go out for consular appointment stamping if I have done change of status to B1, yet to be approved under brackets, yet to be approved, and then get a job?
You don't have to leave the country. Again, it depends on what USCIS says. But if you file for B1 or a B2, and while the B1 or B2 is still pending, or within the 6 months period, remember, if you ask for 6 months, your status is only for 6 months. You have to file for, again, a change of status. And it's, again, based on a bridging petition. So if they approve it based on that bridge petition, then you don't have to leave. If they approve the change of status portion, you don't have to leave the country. Sometimes they might not approve a bridge petition, in which case then they'll approve the H1, but they will not give you an I-94. So then you can leave the country, go to and get a visa if you don't have a visa stamped in your passport, and come back on that H1B approval.
All right. I think you've already answered this one, but maybe a quick answer again. H1B transfer is possible with receipt number only.
What receipt number? Oh, so transfer. I don't quite understand the question. Are they saying that they filed a H1 transfer? Why do they only have a receipt number? Why don't they have the approval? Is it because the employer didn't give them the approval? I need more facts here.
So there you go. Please drop us a note with more facts and we'll be happy to answer.
But in general, if that's the case, I'm just presuming it is. I'm just
Mhm.
going to answer it anyway. If you don't have the approval because the employer didn't share it, you could attempt to then just go to the USCIS website and print out the status. If you have the receipt number, you should be able to type it in and it will show approved status. So put in the receipt number, put in the printout of the status and submit a letter saying that you don't have the approval and why you don't have it. And, you know, USCIS should be able to look into that.
Okay. I guess for the interest of time, we'll take the last question. I know there are a few more questions pending, but to respect everyone's time, we would want to end the session at 1 and we have a bit of more information to share there. So if we are not able to get to your questions, please drop us an email. We'll be sharing our email with you shortly. The last question we'll take for today is one of my consultant is working in a project, but we are filing for her I-140 in premium, but Seattle, premium, but Seattle. WA level 2 wages has increased. Previously, it was 114K, but now it's 127K. Is that we need to file new LCA for him?
So they're talking about two different things. One is an I-140 and one is the H1. So if you're H1, we are filing for our I-140 in premium. Level 2 wages has increased. It was one. So if you don't need to file a new H1, then you don't need to file a new LCA. If your H1 is still has, if you have more time on the I-94, you don't really need to do anything. Now the I-140 is filed based on not your H1 wages, but based on prevailing wage determination done before the perm is filed. So whatever the prevailing wage determination is, it will be based on the current SWA wages, right? So, you know, you have to just follow the process, file the prevailing wage approval and then file the labor, file the I-140 based on the prevailing wage approval and the wages that you put in the labor cert. LCA is something that you file for H1, and that really doesn't have to be filed again unless, you know, they're changing work location. And therefore you need to file an amendment, in which case then new LCA will mean, you know, use of new wages.
All right. And this is the close to this round, and we look forward to welcoming you for our next session